So I just signed on, Judge, over the
Where's he
weekend.
been for the last 4 years?
¿Dónde has estado los últimos 4 años? ¿Dónde has
Son en diferentes lugares
different places?
porque trabajo
Just,
pintura.
Mr. Roches, you're charged with driving.
Okay, pause right there. 1,296 days. That's over 3.5 years with a DWI charge just hanging over him. For context, trials are usually pushed within about 180 days. So this delay, massive. Was he hiding out? Or just stuck in red tape? Drop your theories in the comments. I want to know what you think.
This case is 1,296 days old. We set cases for trial at 180 days, just to give you a little perspective. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Había uno.
Thank you, Judge. An officer is dispatched with traffic hazard and may contact a will witness, another
Un
HPD
testigo,
officer,
otro oficial de policía.
who found the defendant asleep on the wheel, car turned on a public roadway. There was a bottle of Jose Cuervo in the defendant's pocket and an open bottle of beer in the
Había
view.
una lata abierta.
The defendant had bloodshot eyes, slurred speech, and the odor of an alcoholic beverage. The defendant admitted to drinking 5 beers before driving. Concerning sobriety tests were conducted, and the defendant, lawful officers witnessed 6 out of 6 on the HGN, 4 to 8 on the walk and turn, and 0 to 4 on the one leg stand. The defendant consented to breath that came back at .116 and .122.
Mr. Roche, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his NCIC, see what he's been up to and what kind of, if anything, criminal cases he has picked up?
Yes, Judge. Judge, I don't have any cases charged in between this
Entonces no tiene más casos por medio de este.
So you pull up NCIC with new cases?
No, no
No
case.
más casos.
License?
¿Tiene licencia de conducir?
He doesn't have one.
Mr. Roche,
Señor Roche,
I want you to understand something, that I take the protection of my public
yo tengo
the utmost serious.
ayuda.
I don't care who you are. I don't care what color you are. I don't care if you're a small farm animal. You endanger my public. It's really not going to go well for you. You do not have a license. You are not allowed to drive. You will be signing an affidavit with me today. This is a promise you're going to make that you're not going to drive.
¿No vas a manejar?
If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? The worst possible thing you can do is drive
Es
in
manejar.
violation of this court order. I'm also ordering you.
Whoa, that escalated fast. The judge isn't just talking fines or jail time, he's dropping the immigration detainer card. If this defendant's undocumented, it's not just Texas law anymore, it's federal custody and possible deportation. High stakes, high tension.
Illegal drugs or unprescribed controlled medication, I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will put you in jail. No more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission, when you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you get shipped off to immigration. On your ankle, I'm now going to put a GPS monitor so I know where you are at all times. You will get it on today. Due to the age of your case, I will give you 30 days for you and your lawyer to meet to discuss what you want to do.
Hablan a
At
tocar.
the end of the 30 days, you must accept the plea bargain from the state, or we will set your case for trial. But you get no more time.
Si yo no te-
And I'm going to advise you now that if you ever violate, or if you ever take off on us again, your bond will hit the clouds. Do you understand?
Hasta las nubes, usted no entiende. Yes, está bien.
You will pay for the monitor. And then, is Discovery, what do you have on Discovery? Please, let me know.
Well, no, yeah. He's PTI eligible then.
Joe, this case is 1,300 days old. I'm not giving resets. If he's actually going to apply to try to get into the program, he's got to have everything done within the next 2 weeks. You know, I mean, 30 days is the absolute max for
Yes.
him to get everything done.
It's right.
Like,
Let's see, right?
just- Yeah, well, I don't know. They're denying more than I've ever seen before. And because he's absconded 4 years, I don't know how that's going to play into it. So I would probably.
I don't think we need a mitigation. It's gonna come directly from the DAs. Because he's under, it was a .112, is that correct? And then asleep at the wheel.
I don't know. I'm just saying I've seen more denials now than I've ever seen. So before you do that and he has to shell out $300, I would apply first to see if they grant an entry. You know, discovery complete. Great. So if you can release everything so they have it today. Okay, Mr. Roche, we'll give you 30 days. Be ready. You must appear at the next setting. Thanks, Joe. Good morning, ma'am. Ma'am, you're charged with harassment. You're facing, you can stay. It's okay. You can stay. Ma'am, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 12th, 2025, in Harris County, Texas, a law enforcement officer was notified that a parent sent a threatening text message to a school's text communication system. The law enforcement officer made contact with a complaining witness who stated that the defendant sent him a message to have a grandson's birthday party in his classroom and had spoken with the defendant many times via the same number. The defendant brought 25 cupcakes for the birthday party, and the defendant's grandson took the leftover cupcakes home. The next day, the defendant sent the complaining witness a message that stated, "Were you messing with me returning the leftover cupcakes?" That was on call for.
Let's unpack this for a sec. A cupcake disagreement turned into full-blown harassment charges.
Let's unpack this. What started as a cupcake disagreement spiraled into full-blown harassment charges. With profanity, school bans, and threats in the mix, it raises a bigger question. Where's the line between parental passion and criminal intimidation? Should schools press charges in cases like this, or is that overkill? Sound off in the comments.
That nasty. Did you know better than to return germs back to us? You have to be so ignorant and have done that. The next time I see you, I will curse you out. No teacher has ever done that, but it has to be you, ignorant dumbass. Defendant called the complaining witness a homosexual slur and further stated, "Fuck with me or my son, and I will stomp on your ass, you piece of shit." The complaining witness stated he felt threatened because the defendant is always coming to school, being disruptive and cursing at people. The school sent the defendant a letter regarding inappropriate behavior and prohibiting her from any on-campus events. On April 1st, 2025, the defendant called the school and cursed at 2 school employees receiving the letter and made further remarks about the complaining witness.
All right. So I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now, as a condition of your bond, not to have any contact with the school and no one with the school and not to go there. Do you understand?
I'm paralyzed. I was attacked.
I just
I was just mad.
don't say anything. Just don't have any contact with them. Don't use someone else to try to have contact with them. So if you get someone else to try to relay a message, I will revoke your bond and put you in custody. You understand? Now you've got a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Carson and he will tell you if when you have to go back to court. We will have bond conditions created for you. Once you sign them, at that point, you'll be free to go. Okay?
Thank you.
Yeah, if you don't mind just having her hanging out, I'm going to get the bond conditions created. As soon as she signs, you guys can go.
Thanks, Judge.
Okay, thanks. Hi. How's jail? Great. I'm not going to play this game with you. I'm going to let you out today. But I'm not playing this game with you again. I will test you 50 days from today. If I find that you're using, if you test positive, I'm not going to continue to do this. Do you understand? It is your responsibility. You are old enough to know what choices you're making, whether they're good or whether they're bad. You put something into your mouth that's CBD, anything, you put a joint up to your mouth, you put a vape pen up to your mouth. Just think to yourself, you could be wearing orange for the next 4 months. I'm letting you out today, but this is the last PR bond you get from me. You understand?
Sure.
Okay? There's just no excuse. I'm going to test you 50 days from today. You know that you're going to get it. You understand? All right, Beth, done. Thank you, Ms.